Welcome to everybody. There seem to be 75 people here, which is amazing. We are here. This is the first Lawfare Live webinar. I imagine these as a super casual conversation about interesting things that are going on, relevant to lawfare, but not necessarily strictly so. We're going to be flexible. We're going to try to keep fast and loose with what people want to hear. There are two ways for you all to get involved. The first, I ask that you not use the chat function because I will not be watching it, but use instead, please, the Q&A function and send your questions. We will be able to see them and we will answer them that way. The other thing you can do, which is super cool, is if you raise your hand, if you hit the raise your hand button, I can see that your hand is raised and I can call on you, and then you will be able to actually speak. And so for the brave, for the reasonably well-dressed, for the particularly attractive, the option of actually showing yourself is there. All right, so let's get started. With me, whom you can see here, is Steve Vladeck, who was my guest on the Lawfare podcast last week, and we did a kind of a broad look at emergency powers, and we thought this would be a good opportunity, A, to take questions about that, but B, to reprise a little bit of it by way of a setup. Also joining on a very impromptu basis is the ghostly presence of David Chris, who is a disembodied voice because his video cam isn't working, which you can't really blame him for, since the video cam, he had no idea he was going to be on this until I just invited him on. So Steve, get us started with an overview of the available presidential emergency powers that are here to use if the president wants to use them.
Sure. I mean, I think maybe the place to start, given where things went today, is actually a power the president probably doesn't have, which is the power to override local and state level shelter in place or other restrictions by mayors, governors, et cetera, at least under current law. So, you know, as we talked about on the podcast, gosh, I can't believe it was only 5 days ago. There really are four major statutes delegating authority to the president when it comes to responding to these kinds of domestic emergencies. And it's probably right to focus on these four big statutes because the president over time has been understood to have very little in the way of inherent unilateral constitutional authority, that almost all of this is stuff Congress has delegated to him.
And let's pause there for a moment, because often when we think about presidential power and sort of, you know, exceptional authorities, we are thinking about inherent presidential power and the sort of, you know, John Yoo type assertions of power. Why are the president's powers here statutory and not inherent in the office?
So I think, I mean, the short version is because this is an area where from the founding onwards, it was actually pretty clear, and I think even originalists and those who sort of styled themselves originals would have to agree, that the big stick when it came to domestic emergencies, short perhaps of invasion, was meant to be carried by Congress. So for example, in the first militia clause, Article 1, Section 8, the Constitution says Congress has the power to provide for the calling forth of the militia to suppress insurrection, repel invasion, or execute the laws of the Union. And as Justice Robert Jackson writes in his famous concurring opinion for the Supreme Court in the Steele seizure case in 1952, that the Constitution gave this power to Congress and not to the president, was actually a pretty powerful reflection of how the founders thought the separation of emergency powers, at least on the home front, should be parsed out. It's this model that Congress follows in giving President George Washington the power to put down the Whiskey Rebellion. Washington actually follows the procedural and substantive statutory rules to the letter. And so this whole regime really dates back to a clear and I think undeniable founding era understanding that when it comes to domestic emergencies, especially short of foreign invasion, this is a context in which the constitutional authority resides in Congress. Now, part of why I think that's not that interesting or important an insight here is because Congress has delegated much of the power the Constitution confers upon it through these 4 statutes. So, the 4 big statutes in this field, I think the one that folks are perhaps most familiar with, at least before coronavirus, is the Stafford Act. This is a 1980s era statute with origins in the 1970s that was designed to basically, simplify or at least unify how the federal government assists state and local governments and tribes in responding to man-made or natural disasters and emergencies. So when you think FEMA, for example, the Federal Emergency Management Agency, that's Stafford Act territory. The second, and the one that's perhaps more substantively specific to this kind of emergency, is the Public Health Service Act, a statute that was enacted in the middle of World War II. This is basically the source of the federal government's current authority to quarantine, to impose various other restrictions based upon the spread or the fear of the spread of communicable diseases. And we can get into some of the specifics as we go. But when we talk about, for example, what the Centers for Disease Control and the Surgeon General and the Department of Health and Human Services can do, most of that is through the lens of the Public Health Service Act and the regulations promulgated thereunder. The third, one that's been in the news a lot in the last week, is the Defense Production Act. This is a statute enacted in the middle of the Korean War, signed into law by Harry Truman in 1950, that has sort of different levels of measures that the president can delegate the rest of the executive branch to take to ensure that there is sufficient production of those resources that are critical to the national defense. And it's, I think, well understood in the DPA that even a natural disaster can satisfy the DPA, that public health crises are within the bailiwick of the DPA. So the DPA has sort of these escalating authorities. The first is sort of a cooperative authority, where the federal government is basically trying to make it more in the business's interests to supply these resources to the federal government. And then the authorities can get more and more coercive, not contra President Trump, to the point where the government can nationalize business, but to the point where the government can put itself at the front of the line as a consumer and can basically say, hey, business, we want you to make this thing that you're capable of making, but we want you to make it for us, and we're going to pay you market value for it, and we come before everybody else. And so that's, that authority has been on the books for 70 years. That statute's been amended a whole bunch of times, and it's been used, usually the less coercive authorities, but without too much controversy, a bunch of times since. And then, Ben, the sort of the elephant in the room, the last statute is the Insurrection Act. This is the, I think, unfortunately named series of statutes that allow for the president to basically rely upon the military in the form of either federalized National Guard or the Army itself to basically supplement civilian law enforcement, to help ensure that federal law is enforced in particular areas, and in extreme circumstances, if civilian law enforcement and civilian order has totally broken down, to restore order. This is, I think, where some of the martial law conspiracy theories come from, but actually the statute has been used dozens of times throughout American history, most recently in 1992 in response to the Rodney King riots in Los Angeles, where, successful or not, useful or not, I think no one would argue that what the federal government was doing was imposing martial law. I think in those circumstances, what we saw was the federal government using the military to help restore order. And the reason why the statute matters is because the Posse Comitatus Act of 1878 generally prohibits domestic use of the military, or at least the Army and the Air Force, and then as interpreted by the military, the Navy, for civilian law enforcement. But the Insurrection Act is an exception to that statute. So it's these four authorities together that in sort of different quantities, depending upon the emergency, usually represent the principal edifice of the sort of outward-facing federal response authorities. There are obviously a bunch of other statutes that are more internal looking with regard to bureaucratic reorganization, funding, transfers, et cetera. But, you know, we only have an hour and a half.
All right. So, I mean, 3 weeks ago, 4 weeks ago, if we had been having a conversation about presidential emergency powers, we would have been having the conversation about the danger of Donald Trump's abuse of presidential emergency powers, right? Declaring a national emergency to reallocate funds to build a border wall. And he would be up there tweeting as he did, "I have the absolute right to declare a national emergency." And we would be having a conversation about should we be untroubled, disturbed, alarmed, or in 5-alarm fire mode. Now, as we were talking about on the Lawfare podcast last week, we were having almost the opposite conversation, which is here we have an actual national emergency, and the president doesn't seem to want to use his powers, including powers that he should use and that are available to him for precisely situations like this. So if you were president, Steve Vladeck, how much more aggressive would you be in the assertion of presidential emergency powers and the use of presidential emergency powers? And this from lefty law professor Steve Vladeck, how much more aggressive would you be than Donald Trump?
A lot. And I should say, I mean, it is easy to say that with the benefit of hindsight. And so, you know, I think it's a lot of people sitting in this chair would probably have the same reaction. But I mean, I think there are two different points here. One is the dangers of crying wolf, right? That is to say, you know, declaring a national emergency to transfer funds Congress wouldn't appropriate to build the border wall provoked, I think, such a backlash, especially among, you know, those who are not ardent Trump supporters, that there's this natural skepticism that the president could ever have a legitimate claim to emergency power. But I got to say, I mean, guys, if ever there was an emergency warranting the use of emergency powers, you know, a nationwide pandemic like this one is it. And, you know, it's not that this all caught us unawares. I mean, if we rewind the clock to January 31st, that's the day on which Secretary Azar, exercising one of his authorities under the Public Health Service Act, declared a public health emergency, which opened the door to a whole bunch of quiet but important authority shifts, including with regard to FDA drug approval timelines and relaxation of FDA oversight rules, and which I think could have been the beginning of a justifiable ramp up under the Defense Production Act in manufacture and supply of PPE, personal protective equipment for medical workers, of ventilators, given what we already knew by that point about how the disease causes acute respiratory distress. So, you know, Ben, it's not that I think the president would have been in any position to take some of the more aggressive steps that local and state governments have taken over the past 2 weeks. I don't think there was any way, legally or politically, that on February 14th, any president could have said, I'm declaring a nationwide travel freeze, you know, no more air travel, no more interstate travel, yada, yada. I think that just wouldn't have been remotely possible. I think what was missed during the 7.5 weeks between Azar's declaration and where we are today, to say nothing of what we knew before January 31st, is all of this sort of prep time and all of this infrastructure rearrangement that I think the existing statutes unquestionably would have given the president and his delegates the power to undertake if they had really wanted to.
All right. So I actually, David, I'm going to draw here not on your expertise on presidential emergency powers, but your expertise on the interagency process in the context of emergencies in general. And you were head of the National Security Division at Justice in the Obama administration. I'm curious if you imagine how the Obama administration would have on. What do you imagine? We know something about how the Trump administration engaged the subject as it was percolating in China and cases started showing up here. The Obama administration dealt with the Ebola situation, dealt with swine flu. What would the interagency conversations have been like, and how would they have been different?
Well, I mean, for one thing, I guess, can you hear me, Ben?
Oh, yes.
Yeah, good. Sorry about the video. I'm technically challenged. So, I mean, for one thing, the Obama administration had a well-functioning NSC, at least most of the time, or much of the time, that served to incubate and present various policy options in a relatively ordered fashion for decision and endorsement by the president in, I think, what until recently was understood as the traditional manner. And there would have been, you know, still plenty of maneuvering and knife fighting and turf battles between the various agencies. I don't mean to suggest it would have been a smooth, clear process, but it would have been a more traditional process running up through the interagency to the NSC, to the Principals Committee, and, you know, to the president for decision. I think you would have seen a more traditional process. The Trump NSC, as I see it, and I'm not even, don't mean this to sound snarky, is much more of a validating arm or an execution arm on presidential policy, which tends to get set by the president speaking orally or tweeting. So I think you would have had a more traditional sort of bottoms-up process running to the president rather than what we've seen during the Trump administration, which is folks in the interagency trying to interpret what he tweets or says and then carrying that out.
Right. So, all right, Steve, I think this is a good time to open questions up to the floor. So folks, if you're brave and want to do it as a video question, raise your hand. Please use the Q&A box, not the chat, to pose questions, and we will try to address them. So first off, someone asks, there is a CRS document from 2004, executive branch power to postpone elections. Is that still relevant? So Steve, let's talk about presidential ability to postpone or interfere with the elections. What is available for him to do and what is not available for the president to do?
So the short answer is, I think the president would be very hard pressed on his own to postpone the November elections. But I think he could cause a lot of mischief if he really wanted to, and if there were sufficient political support. And let me try to walk through this. So taking the constitutional law first, Section 1 of the 20th Amendment provides that the president's term ends on January 20th, 2021, unless he's been reelected. That's absolute. That's not subject to being overridden by a statute or an executive order, which means that, you know, if for whatever reason, there's just no election between now and January 20th, at noon on January 20th, the offices of president and vice president become vacant, and we end up being left to the auspices of the Presidential Succession Act of 1947. To play that, you know, dystopic Clive Cussler scenario out, or I guess Tom Clancy, the sort of next in line is the Speaker of the House. But of course, if there's no election, there might not be a House. And so then we'd be left with the President pro tem of the Senate, which
Which is Chuck Grassley, by the way.
Well, yes and no. It gets really it gets really complicated, Ben, because if there's no election, then there's 34, I think, seats would become vacant, and a majority of those are Republican seats. So that based on simply who would be left standing, I think Chuck Schumer would actually become the president pro tem. But then you have to go state by state for the vacant seats to see if the governors have the power to fill the seats without a special election. It gets very messy. The short answer is there's no scenario where it's Trump on January 20th at 12:01 p.m. The messier parts are, interfering with the election by, for example, making it hard to travel the day of the election, by encouraging states, especially key states, to maybe postpone the elections on their end, even though it's not clear they could do that under the relevant federal statutes, to encourage electors to basically not follow the will of their state, to basically push for faithless electors. And actually the Supreme Court has a case, one of the two cases I think it really has to hear somehow this term, even though the court has currently not been hearing cases, is a case challenge about Colorado's faithless elector ban. So there are lots of ways, Ben, that I think the president or those who support him could make the elections a lot messier. But that would have to be the step, because without an election of some kind, without something that the joint session of Congress in January could look back on and say that was an election, Trump doesn't get to still be president in January. And so that's why I think it's incumbent upon all of these states, especially given the very real possibility that coronavirus is still a problem in November, to make it easier for voters to vote without actually going to polling places, whether it's vote by mail, no fault absentee, some kind of online mechanism. I mean, that's above my pay grade, but that's I think the most obvious way to try to avoid both the neutral chaos coronavirus might cause and the very malignant chaos that the president or at least some of his supporters might try to cause.
So David, you have written in a question, but I think you should just pose it yourself. So you had a question about Tom.
Yeah, sorry. So Steve, this is so great. I love the structure and the sequencing of your presentation, and I'm learning a lot listening. So I wanted to take on the first point you raised about the constitutional background for this, and how Congress is the dominant player for these kinds of domestic issues. I was wondering, and sort of playing a little game, like you said, maybe Clive Cussler or Tom Clancy style, with something I think Senator Cotton was theorizing about at one point, which is that this virus was manufactured, not just generated naturally in China. And so I wonder, would your constitutional analysis be different if we imagined, and I emphasize this is just, spitballing, playing games, but if you imagine that the PRC developed this virus in a lab and then launched it intentionally at the United States, either at a level that would constitute armed conflict or perhaps at a sub-armed conflict level, just to sort of mess with our economy or something, would you or would John Yoo have a different view about the separation of powers implications and the inherent Article 2 power?
So I think the answer to John Yoo is no, because I can't imagine he agrees with what I said already.
I think he does, though. I actually think he wrote something recently that said this is mostly a state and local issue. It may be that that's politically motivated, but he did say it.
Well, I'll let John speak for himself, including in his forthcoming book about how Trump is the best president for executive power ever. David, I would want to differentiate in that hypothetical scenario between the authorities the president would have vis-a-vis China, which I think would get us back into the conventional debate about the separation of war powers, and the president's power to use force on his own authority versus what he would need from Congress, versus the president's power to respond to the effects of the attack on the home front, which, frankly, has always been understood as a different question from the pure war power question. So, the president's power to take certain actions at home during even times of declared war has often been traced to statutes. There's a ridiculously old, but I think fascinating Supreme Court case from the War of 1812 called the United States versus Brown about the seizure of property on the home front during the War of 1812 that was sort of off the front lines. There are cases from the Civil War, World War I, World War II, where if it's not a military function, David, we've seen still less sort of reliance on Article 2 and more reliance on what Congress has delegated. And I'd like to think that that would be true in the scenario you posit, although obviously I think the executive branch would be inclined to make very aggressive Article 2 arguments anyway. I think the critical point, though, is we're not even having a meaningful conversation in the real sort of world right now about Congress's power versus Article 2 because the president isn't doing anything. And so, you know, this is why I'm so simultaneously horrified and amused by the president's insistence that we should pick a date certain and he's going to order everyone to go back about their business, because it's not clear to me that he has any power to do that, because, you know, if you haven't been doing anything all along, I'm not sure how you stop that.
Okay, we have, oh, sorry, go ahead, David.
No, I was just going to thank Steve. That's an excellent answer, and I appreciate it very much.
All right, so the next question, which I throw open to, I have some thoughts on it, but Steve and David, if you have additional thoughts, feel free. Mitchell Leibowitz asks, does the CDC have any independence, a la the Fed, to override/ignore presidential requests? For example, shutting down federal offices for the purpose of quarantine after the president orders them open. And if so, how are those exercised? So this is an excellent question, and I have not studied it carefully. And I'm speaking here more in my capacity as an NIH brat and somebody who is the child of two federal government scientists and sort of a set of impressions. But my impression is that sort of there are very strong norms of independence in these agencies, that the science that goes on at places like the CDC and you know, at NIH is you know, the reason these agencies are capable of being as effective and as excellent as they are is that the science is allowed to be the science. And that said, like the FBI, that set of guarantees of independence, like the Justice Department, are a big political fiction or a big sort of constitutional fiction. They're things that happen because we all believe they should happen and because the government works better if the science is good. And actually, the head of the CDC is appointed by the president and can be removed by the president and therefore can be directed by the president. And that's true of the head of HHS as well, who supervises all these agencies. And so they are really exactly as independent as the president wants and allows them to be, which is to say, historically, in administrations of both parties, with the exception of certain hot button issues like, for example, abortion, where there are kind of political directives, the agencies are allowed a great deal of latitude, and everybody sort of agrees that the science should be the science. And I do think the premise of the question, which is what if that's no longer true, is a valid one given the way the president has interacted with other agencies. Steve, David, do you guys have anything to add to that?
Nope, thanks.
And I would just say, the only thing I have to add to that is, you know, I mean, we should name names. I mean, Robert Redfield is the director of the CDC. And, you know, if ever there was a time where someone might resign in protest, you know, over sort of complete opposition to the policies of the president at whose pleasure he serves, I would think it would be in a circumstance in which the president is taking massive, you know, either action or at least exerting pressure in outright defiance of the best evidence of what's best for the public health of the country.
Okay, we have a brave soul who has raised a hand, so I am going to add this person temporarily to the conversation. Anshul Rajwanshi, what is your question? We can't hear you.
Hello.
Hello.
Hey.
Hi, Professor Vladeck, Mr. Chris, and Mr. Wittes. Thank you for doing this. I really appreciate it. I'm actually a student at GW, and I'm studying international affairs, and this is a great resource. My question is regarding Professor Vladeck and Professor Chesney. The National Security Law podcast have consistently talked about the Defense Production Act and how it's kind of a no-brainer that the president should be not only invoking these authorities, but then directing companies to. Today we saw the Attorney General Barr was part of the coronavirus briefings. We're seeing that the president is in discussion with the Department of Justice on these issues. So my question is, why is he not taking these actions? Barr has never been someone to move away from executive authority. He's been extremely pro the government, the Trump administration being able to exert executive authority. So is it just that he doesn't understand? Is that there's some underlying narrative? Why does he refuse to enact these seemingly bipartisan, generally well understood authorities that make common sense, that we're in an epidemic, we're in an emergency, you want to use your powers, this is the way to do it?
What are your, do either of you have thoughts on that? I have I have some, but I'm interested in both of your thoughts on it.
David, do you want to go first, or should I?
Please go ahead.
So, I mean, Anshul, it's a great question. And I think there are sort of a couple of different answers, and it might be that the answer depends upon what day it is. I think the president is very averse instinctively to the idea that the federal government should be ordering businesses around. And I think that actually reflects a pretty powerful ideological current that runs through a lot of conservatives and a lot of the president's supporters. There's a story I believe I read yesterday that he's receiving pressure from the Chamber of Commerce, for example, to not aggressively exert authority under the Defense Production Act. So, one piece of this might actually be ideological hostility to what he, I think, incorrectly labeled nationalization of industry, as opposed to just aggressive assertion of government priorities in a very capitalist system. Another possibility is that, this is sort of quintessential Trump, where he wants the symbolism of signing an executive order, invoking the Defense Production Act, but doesn't want the responsibility. And so the more that, it's not his problem that there aren't ventilators in sufficient supply, that there isn't PPE, the more that he can say it's up to individual governors, it's up to states, and we're just a backstop. I think the more that sort of is consistent with his I take responsibility for none of this mentality. And I think to some degree, it also may just betray a lack of understanding of how complicated the DPA is. I mean, I think, I just tweeted right before we started this recording that if you actually go back and parse through the 2012 Obama executive order that I'm pretty sure is the governing delegation under the DPA, it's really not the president's call. Once he unlocks it, once he signs the executive order, it's actually the individual agency heads. So when it comes to medical equipment, it's really Secretary Azar, who arguably now has the authority to sort of pull the trigger. I think this is a perfect example of where broad views of executive power are actually, to some degree, in clash with a combination of hostility to government intervention in the private sector and, the sort of the modern Rehnquistian federalism, where it's just, states first, federal government second.
All right, so this is the part where I get to be, without any reference to his subsequent scuzziness, Woody Allen in Annie Hall, where he pulls out Marshall McLuhan. And because I just saw a question that I thought, wow, I wish I could pose this to Margaret Taylor. And then I noticed that Margaret was on the list of attendees, so I promoted her up onto the screen. I'm going to pose her this question. she just texted me, will I know the answer to this question? I think the answer is yes, you will. At least you'll know more about it than the three of us will. Margaret is our congressional guru. And so this is a congressional question from Richard Ong, who asks, now that Rand Paul and several Congress members have tested positive, what happens to presidential power once Congress becomes unable to meet out of concern for its safety? Do we have any precedent more recent than the Lincoln administration? What does our existing precedent say? So I'm gonna add an important element to that question, which is Congress has the ability to amend its own rules as to the circumstances that under which it will meet and what meeting means. And so but the antecedent question to the are we in the Lincoln administration situation is Congress in the process of thinking about what to do when a whole bunch of members are sick and the process of meeting itself creates contagion possibilities?
So thank you for joining me. I really appreciate it. I'm in my pajamas, so
Steve's wearing a jacket, David's a black box. I'm wearing the old style Lawfare t-shirt, the first ever Lawfare t-shirt.
For the first time in my life, I am the most dressed up.
Yeah, so there you go. Like whatever your jam is.
Pandemic.
Right.
So here are my thoughts. The question was about what happens to executive power if the Congress can't meet. I think the powers that the executive has, obviously continues. The one that is not there, that is a crucial piece, is the appropriations power, and that is exclusively assigned to Congress unless it has been delegated, as we have seen, with the border wall, et cetera. But those circumstances in which the executive can use that power is limited. So the Congress is needed for that appropriation for the money. They are the only ones that can really supply that money from the Treasury. Ben, regarding your sort of more pointed question about what happens if, there's not all, but maybe a substantial number of the members of Congress are getting sick. They have to be quarantined. What do you do? And so actually, Scott Anderson and I wrote a piece about this for Lawfare and published it today. It's kind of an interesting history on that question. And if you've ever spent time watching the Senate floor, maybe the House floor too, I spent more time watching the Senate floor. Sometimes you'll hear senators, they'll say, they'll make a speech and they'll say, I suggest the absence of a quorum. And what that signals to people is it's kind of a delay tactic. But that reference to the quorum actually has its root in the Constitution. There's a part of the Constitution, Article 1, that actually requires a quorum for the Congress to be able to meet, each house to meet and do its business. But over time, as a matter of tradition, the houses they actually presume the presence of a quorum. And that's why they can do things like unanimous consent, where they can pass legislation, even though there's only one senator or one member of the House of Representatives on the floor. If everybody's agreed informally, yes, we're going to presume a quorum, yes, we're going to pass this legislation unanimously, they can actually do it. Which is all to get back to your point then, which is if the senators and the House members wanted to set up a different situation for tougher votes, not unanimous votes, but tougher votes, where you actually, will have a disagreement, they could amend the rules in the House, they could amend the rules in the Senate, they could, be sitting remotely. The idea that Scott and I put forth is, you could have two veins of authenticated communication, so a secure email channel, a secure phone channel, that could be the means for members actually casting their vote, either from quarantine or from back in the States. There's some support for this now among the sort of rank and file in both the Senate and the House. The leadership of House and Senate, though, aren't quite there yet and are pretty skeptical. Both Nancy Pelosi and Mitch McConnell are very much traditionalists, and I think are pretty nervous about this prospect of moving to this type of vote as like a slippery slope, because the whole idea of Congress is that the representatives, the people, get together in one place physically and kind of hash out the problems of the country. And I think both Nancy Pelosi and Mitch McConnell think that tradition is very, very important. So they're quite resistant to this idea of remote voting.
You know, if the courts felt that way, they'd still be riding circuit. And I think, with all due respect to Pelosi and McConnell, that is the dumbest argument. Like, we've always done it this way. Yeah, we didn't, like, you know.
So it was in the time of Henry IV.
Right, and also how the thing about Congress is that the bell curve of intelligence and responsibility is really, really spread out. And, you know, how many Rand Pauls does it take to convince people that actually this is not a safe or reasonable way for an institution to do business, particularly not one that's supposed to model the way other institutions should behave. And, you know, the Senate continues to congratulate itself that it's the world's greatest deliberative body. I would suggest there is better deliberation going on this call right now than there is in the Senate. We're all remote. So I just think, I think it's not a stable equilibrium, and it's going to have to change, because otherwise both the premise of the question becomes accurate, that, you know, if Congress is incapable of exercising its powers, someone else will fill the void. And your answer is also accurate, that there are certain voids that nobody else can fill, particularly appropriations.
Can I just jump in with a historical point on this? I mean, I think, everything Margaret says, I think, is spot on. I would just add, Congress thought about this, at least in many of the early statutes delegating emergency powers to the president, because, I mean, keep in mind that at least until well after the Civil War, you know, Congress was a part-time operation, and was really only in town maybe a couple of months out of the year. And so, just, you know, if we look at the precursor statutes to what today is called the Insurrection Act, Congress actually said, like, we're going to give you this much authority, President whoever, and if we're not in session, you can keep using that authority until 30 days after we come back. And so there actually is, you know, precedent historically for Congress actually legislating into the void and legislating into the potential gap that was much more common, not as a sort of result of disease depriving Congress of a quorum, but just of being out of session. And I wonder if, you know, one of the lessons, whether you are a traditionalist or not, of this experience is the virtue of bringing back some of those, you know, special powers when Congress can't assemble type of statutory delegations, as opposed to leaving it all up to, you know, what Clinton Rossiter called constitutional dictatorship in his classic study of, you know, the first, 11 weeks of the Lincoln administration.
Margaret, thank you for your help on that. We reserve the right to drag you back in if there's another congressional question that requires your presence.
Thanks for having me.
All right, the next question comes from Meryl Chertoff, who says she's interested in the question of federal quarantine versus state quarantine. Federal authorities are very limited at the national border, but in theory, they also apply to interstate travel, which is an essentially untested component. So what are the guardrails for this? So let's actually start this with like a little bit of a top view here. Meryl's point is exactly right. When we think of quarantine authorities, all the law in this, almost all the law, is about state authorities, because, you know, think about like the states with typhoid, right? They would round people up leprosy was what we now call Hansen's disease. These isolation cases were all based on state authority, and the federal role was really limited to when people were coming into the country. So there are these provisions that do seem to go a little further, which involves stuff, as Meryl says, that transits between states. I don't know that I've never seen a case of them being used. She says, untested. I'm unaware of the authority ever being invoked. Steve, do you know anything about whether those powers have ever been used, let alone tested? And what are the parameters of them to the extent that somebody wanted to say, hey, let's really make use of interstate quarantine authority?
So, I mean, the short answer is I don't think we've ever seen the kind of restriction or ban that I take Meryl to be positing. The relevant authority here is section 351 of the Public Health Service Act, 42 U.S.C. section 264, which is itself in turn a broad delegation of authority to the relevant government officers, the Secretary of HHS first and foremost, and the Surgeon General, et cetera, to promulgate regulations governing all of this. And so the real sort of federal law on point is actually a federal regulation. It's 42 CFR Part 70, aka the Interstate Quarantine Regulation. And if you actually want to sort of follow along at home, 42 CFR 70.6. I'm actually going to try to share this on my screen. How's that for technological fanciness? So if you look at the relevant regulation in 42 CFR, that's probably not what I meant to share. Well, this is a good start. So Ben, do you see the regulation right now?
I do.
Okay, so here's the regulation. Let me see if I can make it a little bigger for everyone at home. So if you look at 42 CFR 70.6, yay Zoom, you can see in 70.6a, the director may authorize the apprehension, medical examination, quarantine, isolation, or conditional release of any individual for the person presenting blah, 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 blah. Basically, the director of the CDC is authorized to quarantine individuals based upon a finding that the individual is reasonably believed to be infected with a quarantinable communicable disease and is moving or about to move from a state into another state, or, and I think two's the big one, the individual is reasonably believed to be infected with a quarantinable communicable disease and constitutes a probable source of infection to other individuals who may be moving from a state into another state. So the question I think that Meryl's question raises is, could you read 70.6A2 to authorize the director of CDC to impose something like an interstate travel ban, even though the ban is not predicated on specific findings about individuals, but rather a more general finding that the ban is necessary because there are a number of infected individuals in, say, Texas, and to prevent the spread of the disease to other individuals who might be moving from Texas into Oklahoma, it's necessary to shut down the Texas-Oklahoma border. I don't think that argument is self-evident from the text of 70.6, but I also don't think that it is facially implausible. And so, I think you could construct a plausible argument based on 70.6 that the director could do that. I think we've never seen it. And I think it would be, immediately challenged in court and very controversial.
All right. It's kind of cool that you actually went to the videotape there and that your Zoom game is good enough to actually allow you to warn or wolf it. Our next question comes from David Priest, who I will, as soon as I can find him here, will bring him up on the screen. Although I'm not raise your hand so that I can see you.
Hey Ben, while you're finding David, can I actually answer David Chris's other question about 264?
Yeah, let's have David
loaded
pose that
world.
question orally so that we can, so that people can hear it.
So can you hear me now?
Yep.
Oh, yes.
So my question was taking Merrill's and sort of going even a little bit one step further, which is if you read the statute underlying the regulation that Steve has put up, and I think it's in the reg itself, at least in one sense or another, there's an idea that you might be able to detain, apprehend, whatever, persons who are not themselves going to travel interstate, but who might come into contact with and infect others who might then travel interstate. And so the question is, do you think that that authority to detain such persons is within the ambit of the statute and the reg fairly read? And if so, do you think there's a sort of a new kind of constitutional question presented in the, what I'll call the post-Lopez era of Commerce Clause jurisprudence, where you here are having an indirect effect on interstate commerce, which I take it to be the constitutional authority underlying all of this federal power in the first place. So that's the question basically for Steve.
So I actually think, David, there's a third question, which is, and even if it's within the statute and the reg and a valid exercise of Congress's Article 1 authority, does it nevertheless violate the individual rights of those who are restricted from traveling?
Yeah, great.
So let me try to take this in turn. So, excuse me, there's a curious gap, David, between my reading of the statute, which is what I currently have on the screen. This is 42 USC 264D, which, as you say, seems to encompass authority not just to go after individuals who are already infected, but also those who might not, or at least might be a probable source of infection. But then let me switch back to the regulation for a second. So David, the regulation, I think, does not exercise the full authority the statute conveys, because the regulation focuses on individuals who are in fact infected, or at least who the director reasonably believes to be infected. And there's no third category in the regulation for individuals who are not reasonably believed to be infected, but who are believed to be a risk. So I actually think there'd be a problem with relying solely on 264 D2 in the context that you're describing, because the relevant regulation doesn't seem to actually exercise the full authority of the statute. Now, of course, Secretary Azar or Director Redfield, right, could, issue a new regulation tomorrow that closes that gap. I just think that would be an argument open under existing law. All right, let's assume you could tie that though to the reg. So Ben and I talked about this a bit last week when we did the podcast, and I think it's certainly true that the modern Supreme Court is much more hostile to the use of the Commerce Clause. And I'm going to take the reg down because I think we've made the point. I think the current Supreme Court certainly is more hostile to the use of the Commerce Clause for this species of regulation. That is to say, because we can regulate interstate commerce, we can therefore stop things at borders. But David, keep in mind that in the anti-commandeering case, New York versus United States, one of the things that the Supreme Court was asked to consider as part of the low-level radioactive waste amendments of 1990, I think it was a provision in the statute that actually banned the shipment of low-level radioactive waste out of a non-cooperating state. And before striking down the take title provision, Justice O'Connor, writing for the majority of the court, including the conservatives, upheld the no shipment out of state provision as a viable and acceptable exercise of Congress's Commerce Clause power. So I'm not even sure that the new federalism undergirding Lopez and other cases would extend to this kind of context where Congress is actually not, even under Justice Thomas's view of what the Interstate Commerce Clause covers, the borders, shutting down the borders is consistent with that. If it's for the flow of commerce or people who are in commerce. That's not a perfect argument. You know, I still think you could imagine justices who would be wary of that, especially on the current court. But David, again, you know, when added to the context of a genuine emergency where, you know, the conservatives especially, but I would say actually probably 7 or 8 of the current justices would be inclined to defer to Congress. I don't think it would be a Commerce Clause challenge that would fell such a provision. The messier one, and this is something Ben and I also talked about last week, is the panoply of individual rights objections to such a restriction, right? That, you know, a procedural due process argument that you were, you know, sort of put on a list without any opportunity to prove that you shouldn't have been there. The substantive due process argument that the restrictions were overbroad compared to the policy they were seeking to vindicate, that there were less restrictive alternatives. And the quixotic but very real right to travel, that if it means anything, presumably means a right to travel interstate. So, you know, I think this would be perhaps the most litigation provoking thing the government could do. And it's not clear to me that we're at a point where it's necessary, which I think would be a necessary predicate. But, you know, I don't think any of the legal arguments are sort of clearly pre-indicated in one direction or the other.
Can I just follow up on that for a sec? So I want to make sure I understood you. On the first part about the reg itself, if you had a Rand Paul type in civilian life who was confirmed infected and had no plans to leave his home state, but was not going to refrain from going to the local Dairy Queen and the local basketball game, or if it were on, and so forth.
Was he willing to refrain from going to any federal buildings or interacting with any federal officers?
Yeah, so, you know,
because I think you could invoke federal jurisdiction by, you know, without any interstate travel, merely by dint of, I mean, does he have a summons to U.S. federal court? Is he planning to sue anybody? Is like, how committed to not interacting with a federally protected interest is he?
Well, I know about In re Nagel and the potential ability of the marshals to be deployed to protect federal officers from renegade, virus-laden state zombies. But I was really sort of thinking just about, like Steve's got it back up, whether 70.6A2 and the statutory backing for it would permit you to stop the movement of a local person who had no intentions of traveling interstate on the theory that they're going to bump into somebody who themselves might travel interstate. And it's just an indirect, to the extent that you're relying on commerce power to prevent interstate movement of people or radioactive waste or cattle. And I believe there's a cattle case from the 1930s.
There is.
You know, right. So, you know, does it work if you've got a purely local guy who has no interstate ambition, but is going to breathe on somebody or sneeze on them?
Well, so that's right. So that's where I think A2 is, you know, I mean, the reg, I think, does speak to that more specifically. That doesn't answer the constitutional question, of course.
Right.
But, you know, but the reg does say, you know, whether or not the infected individual is traveling, if he or she is a probable source of infection to others who might be traveling, that's when you can act against the infected person. Yeah. You know, David, again, I think it's a stretch to get from there to act against everybody. But, and let me just sort of tie this back to sort of the moment we're living in, but against a backdrop where we have such inadequate testing and where the government simply doesn't know who's infected and who isn't. You know, could you imagine a government lawyer going into court, or, well, Zooming into court and arguing with a straight face that, you know, we interpreted the reg in these unprecedented circumstances to allow us to act against the community because we lack the ability to isolate the particular infected individuals? I think there are judges with whom that argument would resonate.
Okay, yeah, but you don't have doubts on the constitutional, statutory, or regulatory front about the power to detain an individual from moving intrastate on the theory that he's a vector for others who might move interstate.
I really don't, because I think, you know, given the nature of modern travel, I think that's not going to be hard even for the conservative justices to swallow.
Okay. Great. super. Thank you very much.
Yeah.
All right. So my efforts, which have been ongoing through this exchange to bring David Priess in to ask his question, have failed completely because the editor-in-chief power, while nearly plenary, does not override Zoom settings that are keeping him off the screen. So I will just read his question. David asks, if I remember correctly, one of the Defense Authorization Acts in the late 2000s authorized the president to mobilize National Guard units without the consent of state governors, and yet governors are effectively commanders-in-chief within their own state commonwealths. So what if the president and a governor or many governors disagree about the activation and or specific roles of the National Guard in a public health emergency?
Okay, so now we have to talk about the National Guard, and we're all going to need a drink. The best way to sort of answer this question is to start with something that may be obvious to many but not to others, which is that the National Guard wears at least 3 different hats. The hat that we are all, I think, most familiar with is the pure state hat. And when the National Guard is wearing its pure state hat, it answers to the governor. It is only enforcing state law. It is helping with, say, disaster assistance, law enforcement, whatever. And it's outside the bounds of not all federal law, but at least the relevant federal constraints on use of the military, because in that circumstance, the National Guard is not acting like the federal military. The second hat that the National Guard wears is what we often call the Title 32 hat, a reference to Title 32 of the US Code. And the Guard in this hat is still acting at the governor's command, but is doing so usually with some federal nexus, either at the request of the president or in coordination with federal authorities. And part of why this matters is because more often than not, when the Guard is wearing its Title 32 hat, the federal government's paying for at least much, if not most, of what it's doing. And one of the things that I think happened last week or 2 weeks ago was a memo or an order from Secretary of Defense Esper about reimbursements for Guard under 32 related to coronavirus. And then there's the third hat, and the third hat is the Title 10 hat, which is the federalized Guard. This is when the president federalizes or activates or calls up the National Guard, at which point the Guard is taking orders from the president, not from their governor. That is a bit of an oversimplification. The folks who actually know the Guard stuff forwards and backwards might point out that there's even really a fourth hat, but we'll leave that for later. But to answer David's question, Ben, the critical point that I think folks have to understand is in all 3 of those contexts, the Guard is first and foremost a creature of federal law. That even in its pure state hat-wearing facility, it is still created by statute, by a congressional statute. It is still subject to rules imposed by Congress. It is still constitutionally an arm of the federal government, even if by statute it's not. And so I say all of this just to say that I think if there were ever a conflict of the type that David is hypothesizing between the president and a governor over use of the National Guard, as long as the president was using the Guard in a manner authorized by statute, I don't think there's any question that he'd win. And part of that, again, goes back to the sort of the awkward nature of the Guard and the reality that, at the end of the day, the Guard's principal source of power is federal law, not state law. And so, I actually think that there are plenty of very messy federalism fights that I think we're about to really start seeing. I actually don't think this is one of them, because I think the Guard and the military generally is going to be one area where there might be huge political fighting and huge, sort of political objections, but where the substantive question of, who wins the preemption fight will just about answer itself in every case.
Our next brave soul who wants to ask a question live is Alex Gaynor. Alex, the floor is yours.
Thanks, Ben. Steve, on Twitter, you argued that the lack of testing combined pretty negatively with the judicial notion of a least restrictive measure, because if you don't have the testing, you don't have the data to actually say what is least restrictive. So I don't think anyone would argue that the federal government would allow a pandemic to persist. in order to, or like anyone would possibly allow a lack of testing for that. But more broadly, what tools are available to the judiciary to prevent the government from sort of not doing due diligence in order to not have facts that would undermine the notion that some very broad action was in fact the least restrictive measure possible?
This is a fabulous question. Steve, take it away. I have a couple thoughts on it as well when you're done.
I mean, my short answer is oi. Yes, Alex, it's a great question. I think my first reaction is that the real sort of constraint on that kind that if the executive branch is acting based upon just completely indefensible factual claims, that my hope is that it would never even get into court, that there'd be enough political pressure against the executive. Of course, this is 2020. Who am I kidding? The short answer on the legal side is, any of these measures, especially insofar as they affect private parties or businesses, are going to be challenged in court. And so it's possible that a court could say, we dispute the factual predicate of the government's proffer, that even if we think the government had the authority to do this substantively, we don't think it met the baselines. And indeed, I mean, if you look through, 42 CFR Part 70, the regs that govern most of the aggressive public health authorities, the director of the CDC is supposed to be making a series of findings that presumably, and in some cases explicitly, are subject to judicial review. So, Alex, I think that there are tools in the form of judicial review of the director's findings that would empower the courts to push back. I just don't have a lot of faith that in a genuine public health emergency, I mean, like, that where the folks who are saying it isn't really an emergency are actually the ones who are defending the president the loudest. I'm not sure I have a ton of faith that courts would be in a hurry to push back even on overbroad assertions if they looked reasonable. I'm mindful here of what my friend and our lawfare colleague, Bobby Chesney, wrote a great, I think, 2009 article in the Virginia Law Review called National Security Fact Deference. And the article walks through the very different ways in which courts defer to assertions of necessity and national security and expertise in these kinds of cases. And I don't know that this would be what Bobby would call formal deference on the ground, but I do think these are cases where the government will get a lot of informal deference. And frankly, the benefit of the doubt, especially if, it looked like lesser measures were going to be less adequate to suppressing the crisis to actually protecting public health and safety.
I just add a couple thoughts to that. I do think I agree with all of that. The government's going to get a lot of deference. And by the way, these are the situations in which it generally should get a lot of deference. It is situations like this that the idea of deference emerges from the true emergency situation. That said, one of the oddities of this situation is that the person who is most frequently and publicly questioning the need for the actions that his government is going to take is the president. And so I do think you could imagine a set of litigations that have all of the self-contradictory elements of the census case or the travel ban, where the president is sort of constantly undermining the litigating position of his own government. At the same time, you have these incredibly compressed litigation schedules because the presentation is, a habeas case on a 14-day quarantine, right? And so you really could imagine the deference thing interacting with the preposterousness of the poor Justice Department lawyer who has to go into court in the face of what the president tweeted an hour earlier, and somebody's actual liberty at stake, and 10 days of the 14 days are already gone, and the judge just saying, look, don't ask me to okay this under these circumstances. You've already gotten 10 days of the 14 that you are, don't ask me for the rest. And so I could kind of imagine it playing either way.
I think that's right. I mean, I think, there's litigation risk here largely because there just isn't a lot of case law. And so, I think any responsible executive branch lawyer would have to look at any coercive federal policy in this space as not impervious to litigation. But man, if there was an area where I'd go in thinking that the federal government had a thumb on its scale, it would be in cases like this.
Yeah, agreed. All right. Then.
Meryl wanted me to follow up on the messy federalism fights. Can I get into that for a sec?
Please.
So, I didn't mean to give short shrift to this. So, going back to this whole question of the president's apparently new posture of trying to basically, I think it was Congressman Chip Roy from here in Austin, who said we should pick a D-Day and just, get everybody off their couches and back to work and reopen the schools and, just get the economy going again. Leaving aside the flawed analogy to World War II and how what he's really talking about is VE Day, which we couldn't really predict in advance.
And also that D is a very convenient letter in that it stands for death.
Well, true. So leaving that both the things aside, one of the remarkable things about the president's new bluster is that I don't know what specific actions he could take that would frustrate what governors and mayors and local governments have done. That is to say, I think I said this earlier in the discussion. I don't think there's any source of authority on the president's part to override shelter-in-place orders at the local level. But right, he could, for example, start messing with the funding that states are entitled to under a whole bunch of federal grants to deal with disaster assistance. If he really wanted to cause mischief, he could revoke his proclamation of a national emergency from, I think, March 13th, which would cut off the tap to a whole bunch of resources, not just funds, but other logistical capabilities that state and local authorities have access to once you've declared a national emergency under the Stafford Act. So, the federalism fights here, I think, are mostly political in the sense of, is the president really going to start taking action that sort of widens the chasm between those states that are taking aggressive suppression measures on their own and those states that aren't? Or is he going to make it more painful for states that are taking, aggressive suppression measures to do so? But, I think one of the ironies of how little the president has done in response to this crisis is that it actually deprives him of big things he could do to sort of set a D-Day if he really wanted to. So I hope that answers Meryl's question and also ties back to my sort of why I think this bluster is really bluster.
All right. We have another hand in the air, but before we take it, I want to pose this question from Anshul Rajwanshi to David, who I think is probably best qualified to answer it. Do government officials who work with classified information still go into work, or is there some way to access files at home? I know from my time at State that you can sometimes get a fob to access the intranet, but not sure about classified systems. So I'm going to broaden that question a little bit and say, how is the classified sector balancing the need for social distancing with the fact that there's just a huge amount of material that can't be dealt with remotely?
Yeah, I'm sure it's very challenging for them. Normally, if you are, privileged enough official in the government with a proper clearance and so forth, you can get a GSA approved safe in your house. That's not going to be for the rank and file, but some people can certainly get it, the higher ranking ones. And that'll hold secret level. But to hold top secret paper or compartmented stuff, you're going to need a SCIF built in your house. And that's extremely rare. It's not completely unheard of for cabinet or sub-cabinet officials, but it's certainly not every day. So secret level, you need a safe. Higher than that, you need a SCIF and a safe inside the SCIF. You can have secret level phone calls on classified phones. Again, there are some of those, but they're not given out to everybody, and even classified cell phones. But you can't, it's very hard to do something like this. I've seen them before in the Situation Room with, you know, Admiral McRaven dialing in from Afghanistan and some State Department high-ranking official from their home skiff, and the video quality is considerably worse than Zoom, and you get all these freeze-ups. Now, maybe with more fiber being laid, things are better now. But the short answer is it's not super easy to work from home with classified material and on classified computer systems. And so a lot of these people are going to have to go into the office and just hope to stay 6 feet apart and not sneeze on each other.
Just to follow up on that, I had this realization today that if I were a foreign intelligence service, one thing that I would be doing is really focusing on targeting people at home, which of course they do anyway. But I would think that as more meetings are happening on Zoom, more activity, maybe not at the highly classified level, but at all kinds of sub-classified levels or, you know, lower classification levels are migrating out, that there's just a hell of a collection set of opportunities directed at individuals who are spending more time at home and less time in SCIFs. And I'm curious for your thoughts on that.
I mean, I think you're right. The attack surface, it proliferates and is much less hardened as people are home. And what people will do, even though you shouldn't do it, is they'll sort of try to talk around classification issues, even, you know, using systems that aren't certified for classified. And they'll, you know, remember that thing we were doing the other day with that guy in that place, and so we got to do that thing we talked about with the you know,
with the monkeys,
right? And then somebody will say, you know, in that conversation, you mean the drone strike or something, or, you know, and it'll just be awful. So yeah, people, you know, under strain and who are really eager to fulfill their mission, but are told not to go in, but want to move the ball forward, will you know, will probably try to talk around stuff, and at the margins of that, some of them will screw it up, and that'll get them in trouble. Potentially, and it will provide potential opportunities for the adversary. So, you know, people are going to need to be disciplined about that. But there's a lot of people with clearances and a lot of people who work in the space. And so, you know, the attack surface is going to be bigger, I think, as a result of all this dispersal.
Of course, the attack surfaces of all the adversaries are also bigger.
Yeah, and that may be true, and I hope our community is doing its best to get as much access as, you know, as they can. It's a strange world. I wouldn't be surprised if coming out of this there is some more emphasis on developing applications that allow better, you know, either home or at least non-SCIF use of facilities for classified, because it's a little bit like what you were talking about with Congress. There's just a lot of pressure in that direction, and this episode with the virus is a very acute presentation of that pressure.
Our next question comes from the briefly named Grant. Grant, what's on your mind?
Hi. Yeah, so I'm a little surprised that this topic hadn't come up before, so I thought I'd ask about it. Maybe talk briefly about the intersection of surveillance and public health. So I imagine that, for example, public health authority or public health department, local public health departments can go get a search warrant for CSLI or something like that to track down a particular case. But more at the population level, I mean, are there any existing authorities or techniques that could potentially be redeployed? I think the answer is probably not, because it's all domestic, but I'm just curious to talk about it in terms of, you know, more scalably collecting people's, you know, location metadata to track down cases. And if such a thing were there, I mean, would it would it make, I mean, I know China has done this extensively. Would it make sense for us to do it? I'm certainly very wary about it from a privacy point of view, but certainly less so. Like this, like for me at least, these circumstances call for that kind of stuff in a way that even, you know, perhaps terrorism wouldn't, but I'm just curious to touch on that topic a little bit.
Yeah, so I'll just preface the answers to these questions with the observation that the public health arena and the communicable disease arena in particular is the one context in which the routine use of the word surveillance always has positive connotations. And you'll get, public health officials will say quite cheerfully, what we need here is a lot more surveillance of the, the difference between the way public health people talk about surveillance and the way people in law enforcement people are, of course, use surveillance, but they're always shy about admitting that they love it. And of course, civil libertarians are terrified of it. So we have a culture in law of being kind of shy about and reticent about enthusiasm for surveillance. And the public health people are not like that at all. They want insight into disease spread. So here we have a situation where you're using the term surveillance in both the law enforcement sense and the public health sense simultaneously. I think the merger of those is a really interesting feature of this area. So David, let's start with you on this, since you are the world surveillance guru. What do you think? Are there deployable surveillance authorities that exist at the federal level that can be brought to bear on this, or are these so inflected by interstate and international politics and international relations and law enforcement that they actually just don't migrate well into this space at all?
The statutes don't migrate. They don't. These kinds of issues don't migrate well to either of the two big collection statutes, unless you can, under Title III, the Domestic Wiretap Act, find a way, and Steve might know, to make knowing, interstate travel or spreading of disease vectors a crime. And that, I can imagine that becoming a predicate under 2516 or something for a Title III warrant.
But it's not yet.
Yeah. Right. So, okay. But it's not, it's not really a foreign. We talked at the beginning about the foreign domestic split. The question that I had for Steve was very similar to the one that Grant posed, which is, can you imagine a president or a government using cell site location either to enforce quarantines, like you got to stay home and your phone better stay with you at home, or to reverse engineer the movements of infected persons to help identify those who are at risk. And I was sort of imagining that being done by some kind of downloadable application on your iPhone from HHS, under which you're consenting to move, and maybe even that consent becoming a prerequisite for enrollment in TSA PreCheck, so that they condition privilege of speedy airport access on the government knowing where you've been. I don't know whether that would be okay. I think after Carpenter, we are newly sensitive to location data. So I'd like Steve to tell me what he would think of those things.
So I think, David, I think Carpenter is actually less of a complication than it might seem, and that the real problem is the statutes. I mean, keep in mind, Ben, that the public health statutes predate almost all of our modern technological surveillance capacities, and so don't account for this, I think, in any meaningful way. And without a statutory basis for the surveillance, I think the constitutional analysis is moot. So Carpenter does put teeth into the idea that the government's use of historical cell site location information implicates the Fourth Amendment, and therefore should at the very least satisfy, be reasonable and perhaps even be warranted, or at least fit within an exception to the warrant clause. But David, if ever there was a special needs case, I would think it was a public health crisis, because the special needs doctrine recognizes an exception to the warrant clause for those regulatory searches, so sort of mass suspicionless searches that are done to vindicate a special need of the government and not for a law enforcement purpose. Right. So like a sobriety checkpoint in an area where there's been a high incidence of drunk driving, or, you know, checkpoints at the airport or things like that. I would think that mass surveillance, been in both senses of the word, right? That, you know, surveillance of data for the purpose of gaining surveillance of public health information. David, I think courts would have no trouble treating that as a special need, where the question would simply be whether the underlying surveillance program was reasonable, because we jumped right over the warrant clause.
Yeah. So just can I just add to that I think to the extent that we're thinking about electronic surveillance, I don't think that's where the action is going to be here. I mean, just to use one example, viral infection is a lot of things. It's not an electronic communication, right? And so the statutes are overwhelmingly devoted to forced capture by one means or another of something that could be considered electronic data or communication. And that's not actually what we would be trying to surveil here. I think the real surveillance action here is going to be ambient body temperature checks. And that falls, you know, that is, you know, you couldn't walk outside in China for more than a month without somebody taking your temperature. And I could imagine that being justified on a basis very similar to a sobriety checkpoint, and falling, and that's the kind of mass surveillance that I think we're realistically going to be dealing with. It's, you know, people making sure as people go back to work that they have their temperature taken before they walk into a public building, before they walk into their office, before they or
have one of those wristbands from Contagion.
Sure. Or now, of course, there gets to be an electronic dimension of this, right? To the extent that somebody creates the wristband that interacts with your phone and collects your temperature data in an ongoing way. And so Apple has surveillance of it in the public health sense. So I don't mean to say that there's no electronics component of it or data collection component, but I think the front lines of it is probably thermometers.
I think that's right. Can I say one more thing though?
We have to wrap up in 3 minutes, so keep it brief.
So let me do just really quickly in response to one thing Grant said that I don't think we've responded to yet, which is wholly apart from the law. I mean, I think there's a debate about whether this is actually a good idea. And I want to sort of refer folks to this week's episode of the National Security Law Podcast, where Bobby Chesney and I actually spent a decent chunk of time fighting over the sort of the wisdom, at least in the CSLI context, of this kind of mass surveillance. And I tried to sort of highlight reasons why it's not self-evident that it would be, you know, as useful as we might think.
We are going to leave it there. It is, we have 2 minutes left, a few minor administrative things. This is the first time we've done this. We wanted to be very informal, to keep it conversational, to involve audience members as much as possible, and to be kind of fluid about what we were doing, including dragging David and Margaret in midstream. Please let us know how it worked, how we could be doing it better. We also want to do a fair bit more of these. So what are topics in this crisis situation that would be useful for Lawfare to have these sort of conversations about? So please, you know, send us your feedback, email us. I'm very reachable at benjamin.wittes@lawfareblog.com. And you can also tweet abuse at me at Benjamin Wittes. You can even occasionally say nice things, though not that many people like to do that. Look, to the 115 people who, somebody asks whether this will be archived anywhere. We are, I think this was interacting with YouTube Live and was live streamed on YouTube as we did it, and it will be archived there if we were successful in doing that, and we will put it on Lawfare. So we will be doing more of these, and to all of the 115 of you who made it through the entire thing, thank you, and to everyone else who joined us for part of it, thank you as well, and to Steve and David, thank you guys for inaugurating this series with me.
Happy to do it.
It was great.
All right, I declare us adjourned.
Good night, everybody. Stay safe out there.